Good afternoon. Thank you, Dr. Gorbani, for the invitation to speak here at this forum, and thank you, Griffin, for the kind introduction. As Griffin just mentioned, I am the lawyer in the room. I'm a member of the law faculty at UNB Law, and I'm thankful for the opportunity to speak at an industry summit and sit among cybersecurity experts and industry leaders. Although I'm intimidated when speaking to such an expert, including technical audience, about cybersecurity, the imposter syndrome that Elaine talked about earlier, I do see how law and policy, which are the domains I'm more comfortable with, are increasingly and will remain, I think, a crucial part of our conversations about cybersecurity practice, especially for this year's conference theme, which is attribution. So I want to focus on definitions first. What do lawyers define as attribution? Attribution can be broadly defined as the process of assigning responsibility for a malicious cyber activity, assigning responsibility to a specific actor on the basis of specific available evidence. That includes intelligence, forensic investigation, etc. So here, I want to emphasize that to attribute a cyber operation at the end of a long process, which involves technical investigation, suspicion first, technical investigation, accusation, and possibly ends up with attribution and consequences, is a decision. So to attribute a cyber operation, especially to attribute a cyber operation politically and legally speaking, is ultimately a decision. What do I mean by that? The process of attribution embodies several concrete choices and dilemmas. These concern the level of certainty, including legal certainty, to arrive to the decision to attribute, quality of the evidentiary standards, and what is the concrete response? What are the response instruments that are available to an entity or a state in response to the malicious activities, which could range from issuing a statement, beginning a criminal investigation and prosecution, imposing restrictive measures, etc. Which brings me to the next part of my talk, where I focus on typology, the different types of attribution. I will be speaking about three types of attribution. One, technical. Very briefly, most of you here have been talking about ways to investigate cybercrime and investigate cyber operations. So the technical side, and then I distinguish between political and legal attribution. So the technical dimension of the attribution involves computer security incidents response teams, national cybersecurity and law enforcement agencies. This is the investigations that are generally conducted at the victim organization level, be it an organization in the private sector or the state. So in Canada, we've heard from leaders from the Canadian Centre for Cybersecurity, the National Cybercrime Coordination Centre, and Canadian Anti-Fraud Centre. We've heard earlier from Chris Lemon how this is a team sport, and one of their slides indicated all the players. Now, there are also teams working in the national security sector across the nation and in various provinces, the provincial prosecution bureaus, etc., as well as expert academic partners like CIC. Now, globally, there are cooperation groups. There is cooperation. See organizations like Interpol, Europol, the Five Eyes, et cetera, et cetera. However, all this landscape of technical attribution and the work that we're doing in this space and the work that you're doing in this space is not identical to the discussions and the world of political or legal attribution. The notion of practical attribution is theoretically and practically distinct from political and legal. What is legal attribution? Mostly thinking about the different, because of the distinction between national and international law, we have two main categories, two main fields of law that we're looking at when we're talking about legal attribution in law. One is criminal law and then international law. So criminal law, we caught the cyber criminal. What do we do with them? The simple answer is that we take them to court and they'll end up in jail. Well, I think this is too simple or simplistic, because in law we consider criminal punishments to be the harshest intrusion into personal rights, and therefore it's the last refuge. It's the ultimum refugium, as we call it in fluent Latin. It's a national process, and individuals can be subject to the criminal process, not state actors. Individuals like the Lockbit, individuals behind Lockbit or other such schemes that we heard earlier. So the state cannot be criminally indicted. That's why we have a separate legal basis for attribution, which is international law. In the space of criminal law, we only deal with individuals. A set of rights are triggered, which means that the individual would have the presumption of innocence, rights to defense, etc. Privacy laws are now coming into play. They will define which kind of evidence is actually admissible before a court, and a proper procedure that is defined by rule of law with rule of law nationals is always in place. See search warrants and all the agencies and safeguards involved. So a more recent challenge when it comes to criminal attribution has been this new AI-enhanced type of cybercriminal activity, and particularly misinformation. That's where things get a bit tricky, and privacy laws might come to assist criminal law. See cases like Cambridge Analytica that brought privacy laws into the forefront. The legal certainty that we need to have in order to finally condemn in a criminal context is high. So in most Anglo-Saxon criminal justice systems, including Canada's, the court should base a judgment on high certainty, right, beyond a reasonable doubt threshold. Therefore, the evidence that we need to gather, and this is where legal attribution is in conversation with technical attribution, needs to be strong and will need to become public. Now, moving to the international law dimension of legal attribution, international law would be primarily preoccupied with answering whether and which norm of international law has been breached, in order to then move to the question, who is responsible for this? So when it comes to international law, there are two key questions. One, state responsibility. We're not dealing with individuals anymore. We're dealing with states. And two, the associated evidentiary standards, which are hotly debated in international law scholarship. Another interesting challenge with international law is that states are often assisted by private individuals or groups. We are looking for direct support, not mere sponsoring of a cyber operation from a state. And sometimes we also have the so-called patriotic hackers, which act on behalf of a state, however, are not exactly, well, they claim they act, but they're not exactly acting on behalf of states. So that complicates things in the international law arena. Which brings me to the third category, the political attribution, which is again distinct from legal attribution. Policymakers define an incident in terms of as a political problem, and then they will look into remedies. So unlike in law, where we're looking at norms, and if they're applicable, then we have certain processes to follow. Policymakers need to take more factors into account, more parameters, not just legal norms. alliances, attribution coalitions, geopolitical dimensions, and political consequences. So here, my main thesis, my main argument before you is that although the technical, legal, and political attribution are three distinct notions, they're part of the same larger picture. They're connected in the sense that the technical attribution and investigation attribution will trigger political and legal attribution. Now, again, back to what I mentioned earlier, attribution is a choice. So you can imagine a state not making the choice to openly, publicly attribute a certain operation to another state for political reasons. And then for legal attribution, since we saw that the threshold is high, initiating the whole process that does not guarantee that we will reach an end, a criminal conviction, for example. In the international law space, even worse, it's difficult, even if you end up not only accusing, but proving that another state has conducted a cyber operation against you, another state. Which forum will resolve this is a huge question mark. We don't really have a global cybersecurity court to solve these issues. If we if we imagine that there would be two states coming forward and saying, you initiated X cyber operation against me. So we will have the opportunity to talk more about a lot of these things also in the panel that follows. A few final remarks before that. I wanted to acknowledge that attribution is difficult. I imagine it's quite difficult from a technical standpoint. It is also difficult from a legal and political standpoint. Evidence is hard. The cross-border element makes things complicated, and this really explains why states are investing in capacity building and information sharing for the purpose of attribution, and also in sharing good practices with industry, as we're seeing in this room today. Yet, even if it's difficult, even if attribution is difficult, I think it will be increasingly becoming easier. With the current speed of development of cyber capabilities, we have seen evolution not only in the cyber security practice space, but also evolution of norms at both national and global levels. And all these factors are factors that will continue to advance what I think is a common objective, attribution and accountability in cyberspace. So we're building this capacity together, both nationally and internationally. Thank you. I look forward to your questions if you have some.